For Kashmir, we had a ministry in the union government, the Kashmir Affairs Ministry, which was headed by Iyengar. But for everything else, it was Sardar Patel. And apparently there was a little bit of kind of discomfiture between the two of them about that. So Kashmir's unique position, and the reason why I'm saying this is because in the second NCT judgment, your lordships have unanimously looked at 239 AA and Delhi as being not just a simple union territory like the rest of them, but being a little different. I'm canvassing the same for Kashmir. It's very clearly different. There is a different arrangement. Its inception was different. Its birth was different. Its life has been different. It's got a constitution. It's been running 70 years. Now, if you're going to upset it on a mere ipsy dixit overnight, there's obviously some basic procedures and protections which are provided in the constitution have to be met. That's all we're saying. We're not saying that you can't do this, especially when we have reached this far. In 1908, I'm sorry to digress, but in 1908, in the marathon in the Olympics, there was an Italian man who was a male man who took part in the Olympics.
Yes.
His name was Dorando Pietri. Dorando Pietri reached, after finishing the entire 42-kilometer stretch, reached the stadium, and I think it was Paris, and he ran into the stadium, and then he was so exhausted and dehydrated that he was collapsing. So thrice, the umpires, referees, people who were standing near, helped him pass the finish line, and he came first. And then they stripped him of his medal. They said that you took help and the rules don't permit you taking any help of any sort whatsoever. But he did the running himself, and they disqualified him. The reason I'm mentioning this is pretty much where Kashmir had come with adopting India's constitution. We had entered the stadium, Kashmir had entered the stadium, it was near the finish line. There was an illegitimate assistance given to get it past the finish line, which is completely unnecessary. Completely uncalled for, contrary to procedure. You lose a gold medal as a consequence. Also, my lords, the promises that were made at the beginning of the constitution as against now. There was the people of Kashmir through the Constituent Assembly took the decision not to anyway adopt, exercise Article 370 clause.
Not, I mean, just as a hypothesis.
Yes.
It's sort of worrying me, and therefore I'm putting it to you at this point. Maybe a little digression.
Yes.
Can we not possibly read Article 370 as indicating two terminal points?
Yes.
The first terminal point is in clause 2 of Article 370, namely the formation of the Constituent Assembly of the state for the purpose of framing the constitution.
Framing the constitution, that's correct.
The second terminal point is indicated in the proviso to clause 3.
Yes.
That again refers to the recommendation of the Constituent Assembly.
Correct.
Interestingly, 370 is silent on what the regime should be once the Constituent Assembly is formed and has taken a decision.
Which is why two views.
There's complete silence.
Yes.
Right?
Yes.
If there is complete silence in Article 370, then 370, possible interpretation, has worked itself out both in relation to clause 1 and in relation to 2 and 3.
That's a possibility.
Right? In which case, once that happens,
yes,
then we have two options.
Yes.
Your line of thinking would be then, but therefore then the constitution of the state of Jammu and Kashmir will fill in the void, yes, and that will trump, and that will be the supreme document.
Yes.
The other view possibly is, can the constitution of a federating unit ever rise above the source of the federating unit? Because we've always sort of presumed, because, the COs sort of led us up a certain line of thinking.
Yes.
That may have been done. That may have, we're not saying at all that that was unconstitutional. It would be very, very improper. I mean, not improper, but obviously these are statesmen who have operated this nation for the last 70 years. And we shouldn't say that, well, they did something which is unconstitutional. They did that to sort of further the course of governance in the nation.
But the judgment in Sampath.
They did that to further the course of governance in the nation. But if the terminal point of 370
yes,
is the Constituent Assembly's work,
yes,
then is it not necessary that the work of the Constituent Assembly of the state of J&K has to be embodied in this constitution to make it operational.
It's not necessary because it's not provided for by the Constitution. The Constitution looks at the Jammu and Kashmir
It
Constitution.
depends on what view of our federation we take.
Yes.
And if that is not so,
Yes.
then is it not also possible to a construction? Then where was all this exercise necessary? Abrogation and everything.
Yes. No.
Abrogation postulates that it continues. Could be, yes. As we ourselves said that they applied 370 even post 1957 by all those COs.
Correct.
But if 370 works itself out,
No, if it works itself out, I'm with your lordship. I think we must rethink all these different ways of looking at it. But if it works itself out, it can't be touched thereafter. It's worked itself out. It exists in the Constitution.
no, it doesn't exist in the Constitution.
No, I'm
It's a provision.
clearly on the text.
No.
Without being able
But
to
it's
be touched.
completely, but the text, it is there in the Constitution,
Yes.
but it's a provision of the Constitution which itself points out its self-limiting character.
No, and
Right. So it's not obliterated. But if the text itself shows its self-limiting character, then the very operation of 370 has to come to an end once the Constituent Assembly of the state was formed. And that is a key reason why both 2 and the proviso to 3, that you are in a way possibly right. I mean, we'll have to, of course, when I say you're right, it's part of the process of reflection. We have only finished half the arguments in the case, on the angle of finishing half the arguments. That the proviso to 3, when it speaks of, it doesn't say, what does it say?
necessary.
Declare that this article shall cease to be operative or shall be operative only with such exceptions or modifications.
Yes.
This exceptions or modifications finds expression in 2 parts of this Article 370.
Yes.
Clause D.
Yes.
D refers to subject to such exceptions and modifications
Correct.
as the President may specify.
Yes.
The second is Clause 3.
Yes.
Shall be operative only with such exceptions and modifications as he may specify.
Yes.
So, if you see A 238 will not apply. If 238 applied the part, was part 6 of the Constitution.
Yes.
Part 6 of the Constitution dealt with the executive, the legislature, the governor, the high courts, and the subordinate courts. There were 5 provisions of part 6.
Yes.
That will not apply. If that will not apply, what would apply? It can't be that there was no executive, governor, legislature, high court, or subordinate courts in Jammu and Kashmir. 1939 arrangement would apply. All right, that's an indication of its being a very pro tem sort of a measure. Then Parliament may modify. Parliament may make laws with respect to those which are covered in the instrument of accession.
That's describing power of Parliament.
For Parliament.
Yes.
Then such of the other provisions of this Constitution, then comes Article 1 will apply.
Yes.
Right? Then D says such of the other provisions. Now, which are the other provisions? Otherwise, other than what is stated in clauses A to C,
Yes.
that is 238, power of Parliament to make laws, Article 1.
Yes.
Such of the other provisions will apply with such modifications and exceptions as the President may make.
Yes.
All right? No such matter which pertains to the clause 2 will be made unless, it has the concurrence of the state.
Yes.
Then why does 2 come in? 2 comes in that in case the consent was given before the Constituent Assembly was formed, place it before the Constituent Assembly.
Yes.
The terminal point of clause 2 is the Constituent Assembly.
Yes.
What does 3 say? Notwithstanding anything in this article, notwithstanding not anything in the Constitution, but in this article, the President may declare that this article will not apply, not any other provision.
Three, in my view, overrides 2 and 1.
Absolutely.
3 stands right at the very top.
Because of the notwithstanding,
Which is why,
non-obstante
just
clause.
1952 order for a minute.
Right. So that
In terms of 3.
Right. 1952 order, therefore, was the only order before 2019 which applied clause 3.
Correct.
The point now is this.
Yes.
That is there not intrinsic evidence that 370 itself is self-limiting once the Constituent Assembly has come to an end?
As far
And
as we
if
are
it is
concerned,
self-limiting,
clause 3 comes to an end with the Constituent Assembly. That's our argument.
But then the point is this. Then do we say that our Constitution must be so read to treat the Constitution of J&K as an overriding document which will apply in preference to our Constitution?
Because if you see the Constitution of Jammu and Kashmir, it differs to the Indian Constitution.
Absolutely. You're absolutely right.
It only
In which
makes
case-
small nominal changes. And
In
all
which
its-
case,
yes.
really speaking, though the Constitution of J&K framed its relationship with the Union of
Yes.
India,
Yes.
unless that relationship was embodied in the Indian Constitution, how will it bind the Dominion of India or the successor parliaments or the executive here?
For the simple reason that when the Indian Constitution specifically recognizes a constituent assembly for only one state in the country and says that constituent assembly has the task of deciding to abrogate the clause or not, the constituent assembly and its task, which is described in clause 2, is constitutionally recognized. So the fact that there is a constitution coming at the end of this is an obvious corollary.
Does that mean that therefore anything that was said by the Constituent Assembly of J&K would bind the nation, bind Parliament or bind the executive here?
Couldn't.
It had to be embodied subsequent to 1957 in a binding arrangement reflected in our Constitution, which was never done.
That
Because everybody started working on, a working arrangement. The idea was to sort of, gradually bring J&K into the mainstream. Therefore, they didn't want to do that.
Which is thankfully what has happened, and which is why if we take the extreme position that there is no question of 370 subclause 1 continue after 1957, in fact, abandon this interpretation of 370 except to say one last thing. 370 clause 3 says President may. So 370 clause 3 need never have been operationalized. Please note that. If the recommendation didn't come from the Constituent Assembly at any stage, then the President would have nothing to decide a recommendation on. So while the Constituent Assembly was on, if 370 clause 3 sat there quietly in the waiting room and was never called in, and then the Constituent Assembly went after the Constitution came in, 370 clause 3 would expire there without it ever having been operationalized, because it's a question of may, necessary, recommendation, Constituent Assembly. With those four absent, there's no question then of it being operationalized. But your Lordship's question on Jammu and Kashmir Constitution being recognized here, the Jammu and Kashmir Constitution refers to the Constitution of India as it goes through its avatars. That's in the definitional clause. There are several articles that refer to the Indian Constitution. All the COs that came after 1954 and including 54 refers to the Constitution of Jammu and Kashmir. So as Mr. Subramaniam said, there is a bridge, and that acknowledgement is there even in correspondences which have been shown to that extent. But the answer has to be no. If your Lordship's question is the Constitution of Jammu and Kashmir referred to in the Constitution? No, it's not. But it's understood that it's there. It's a classic federal situation like in the US, where states have their own constitutions, flags, etc., etc.